Where do federal and state employment statutes differ? Recent discussions around workplace rights have sparked interest in understanding how federal and state employment laws vary. With ongoing changes in legislation, it is essential for employees and employers to stay informed. Many are currently searching for clarity on this topic, especially with new laws being introduced. Federal statutes set the minimum standards for workplace protections across the nation. These include anti-discrimination laws, wage and hour standards, and workplace safety regulations. For instance, Title VII of the Civil Rights Act prohibits discrimination based on race, color, religion, sex, or national origin. The Fair Labor Standards Act establishes minimum wage and overtime pay requirements. In contrast, state laws can go beyond these federal protections. Some states have their own anti-discrimination laws that cover additional classes, such as sexual orientation or gender identity. Additionally, state laws may apply to smaller employers than federal law requires, offering broader protections to more workers. Paid leave is another area where federal and state laws differ. Earlier this week, the federal government enacted the One Big Beautiful Bill Act, which expands paid family and medical leave. This new law includes lower eligibility requirements and allows state-mandated paid leave to count toward the federal tax credit. However, states vary widely in their paid leave regulations. Some states have mandatory paid family leave, while others do not, requiring any paid sick leave at all. Workers' compensation laws are primarily governed by state regulations. Each state has its own rules regarding benefits and claim procedures, which can lead to significant differences. Federal workers' compensation laws apply only to specific federal employees or industries. Healthcare employment laws also illustrate these differences. Federal regulations, such as the Health Insurance Portability and Accountability Act, set core standards for patient privacy. States may have additional regulations that complement these federal laws. When it comes to wage and hour rules, the Fair Labor Standards Act sets the federal minimum wage. However, many states have established higher minimum wages, and employers must adhere to the more favorable standard for employees. Enforcement of these laws is handled by different agencies. Federal agencies like the Equal Employment Opportunity Commission enforce federal laws, while state agencies manage state laws. This can lead to different procedures and remedies for employees seeking justice. Understanding the distinctions between federal and state employment statutes is vital for both employers and employees. As legislation continues to evolve, keeping informed about these differences will help navigate workplace rights effectively.